ez'enjawulo. Tugoberere ku YouTube, Facebook, Twitter ne TikTok. Mega Promotions TV. Oyagala okumanya ebifo mu nsi nga bw'etambula? Biki ebifa ku serebuwo, ebisanyusa wamu n'ebikuzimba? Oyagala okumanya ebifa mu entertainment industry mu nsi yonna, okutwaliza awamu, okunno kwogatta n'amawulire agafa mu sekita ez'enjawulo? Tugoberere ku YouTube, Facebook, Twitter ne TikTok. Mega Promotions TV. Oyagala okumanya ebifo mu nsi nga bw'etambula? Biki ebifa ku serebuwo, ebisanyusa wamu n'ebikuzimba? Oyagala okumanya ebifa mu entertainment industry mu nsi yonna, okutwaliza awamu, okunno kwogatta n'amawulire agafa mu sekita ez'enjawulo? Tugoberere ku YouTube, Facebook, Twitter ne TikTok. Mega Promotions TV. Oyagala okumanya ebifo mu nsi nga bw'etambula? Biki ebifa ku serebuwo, ebisanyusa wamu n'ebikuzimba? Oyagala okumanya ebifa mu entertainment industry mu nsi yonna, okutwaliza awamu.
All right. Good. Nedda kkooti tenaba kuggwa. Kkooti ey'abangi ewedde, tulina kkooti ya Alex naye nakakola quality.
kiba kinene ng'omunene.
Yes, eyabanje egenze tulinda Alex Waiswa Mufumbiro tetubanga gyetulinza tulabe omulamuzi n'asalawo ki ogumulaga ye taata we bandi taata wa Alex oyo. Taata wa Alex Waiswa Mufumbiro ng'abuzaako meeya w'e Nakawa muyite Ali Bukenya kuba n'okuyaniri obulonde. N'ekirala mawulire agaliwo Luyonga Godfrey omumanyi nga kansala w'e Nakawa gwe baali balonze okukulira Nakawa tu. Amawulire agaliwo jjukira Electoral Commission yagamba baddemu okulonda ne baddamu okulonda baakuzeemu yesterday ne babadde olwokuna neera bingi byakoleddwa mu kalulu kaneeno yadde abalonzi tebajjungidde bangi naye nyongera okubategeeza nti yawangudde akalulu k'e Nakawa Luyonga Godfrey era ne baddamu ne bamulangira ogwokubiri. Kati tetumanyi kulumu oba banakkiriza oba baneekwasa naye nga yalangiriddwa n'aweebwa ne dokimenti eyo gye bagaba bagita bate declaration form ne bagimuwa okulaga nti yawangu. So mawulire malungi agava e Nakawa tu owa Nuupu yazzeemu n'atwala ekifo ekyo oluvannyuma lwa Electoral Commission n'abamu abaali bagoberera abaali abalabe oba ba opponenti baffe nga bagoberera ebyo bagamba waliyo emiruka egitaalonda so tuddemu tulonde. Naye nga omanyi Nuupu twamaze neera ne tujjayo wiini mu Nakawa tu Luyonga e Nakawa LC5 wa Nakawa twali tutidde nga tumanyi ekifo kijja kulandinga mu mikono gya NRM oba bubeera ku nkenke bwereere.
Mega Promotions TV mwena abagyekumiddeko tulina kawa Kanyanya tuli Kanyanya omusango bagukyusa ne bagujja mu kooti y'e Nakawa ne baguze Kanyanya. Kati ensonga bwezito bweziri. Yes, Alex Waiswa Mufumbiro aleeteddwa mu kooti olunaku olwaleero okulaba nga ate baddamu okuba nga bawulira omusango. Jjukira twasembayo baali bamaze okuba nga baagala omusaako omusango omulala naye ate tekyasobola kubeera nga bannamateeka baateekawo embeera ey'amaanyi. So tulaba abakulu Joel Ssenyonyi, Lope Leader of Opposition n'abakungu abalala abaze okulaba nga babeerawo nga bannamateeka ba Waiswa Mufumbiro okubeera ng'ensonga zigenda ddala mu maaso. Tugenda kuba nga tuba updates nyingi nnyo ku bigenda mu maaso n'ebigenda okuba nga bituukiddwako. Kyetusuubira okuba nti ensala egenda kubeerawo naye kyetwagala okuba nga tuwulira abasibe baffe oba abasibe bonna nga bwe baliyo banaabawa beiru kubanga twasembayo okuba nga tulaba wali eri nga abasibe tebaagala kubaweerako ddala beiru. Kino kitegeeza ki? Bategese okubanga abasibe bano babawa beiru nga okulayira kuwedde okwobwa pulezidenti. Tulinda tulabe ensonga zino. Nali njogerako emabega kawo ne Hudu n'agamba nti po engeri gye wayogeramu nti abasibe bonna bayinza okubatanga okulonda kuwedde n'okulayira nga kuwedde. ensonga bwezito bweziri tugenda kuba nga twetegereza ebintu bingi nnyo kuba tosobola kuŋŋamba nti obeera oyongezaayo omusango oyongezaayo kuwulira omusango nga towa abantu kye basinga kuba nga bayaayaanira. Tulaba wano Kato muto wa Waiswa Mufumbiro, jjukira bano bonna bannamateeka, tugenda kuba nga tulaba ki ekigiddako mu maaso kooti nga bwetambula. Mwenna tubagamba nti yita munno sharinga live eno kubeera nga tukuwa ekyo ky'osinga okuba nga oyagala okuba nga owulira nga weeteekateeka. Abakungu bo batiruse dda okuba nga balinda bulinzi mulamuzi abeeko byatugamba bye twagala okuba nga tuwulira byokka. Mega Promotions TV tukusaba okuba nga osubscribinga ensonga okubeera ddala nga tuzitambuliza ddala bulungi mu maaso mwenna abagyekumiddeko.
Here's a team of lawyers, Fred and Rami. Appearing together with the civil criminal fund. Kakuru Musime. Kakuru Musime. Ray Wamanya. Hello to Jonathan. Danteza Juliet. Katorona. And Mr. Joel Senior. For the accused person. Another accused is president. Coming up for the state's rescue. The application by the accused through his lawyer. The application by the accused is that the charge sheet is that this court makes a finding that the charge sheet be found curably effective. Your Honor, and I will report verbatim the objection by learned counsel. Same with you, Frank. And I quote, I submit that the charge sheet and charge are incurably effective in as far as it affects the accused person retrospectively. He went on and quoted Your Honor, Article 28(7) of the 95 Constitution is to the effect that no person shall be charged with or convicted of a criminal offense founded on an act or an omission that did not, at the time it took place, constitute a criminal offense. He went on, the charge sheet and the accused was at Nakawa in criminal case number 0572 of 2025. The court discontinued the charge and set the accused free. Your Honor, if you allow me, he continues. It is now quite absurd that to have the same person appear in the same charge before another judicial officer in another court. I emphasize that he cannot be charged retrospectively. Your Honor, I've had the benefit of looking at
Your Worship, if I may, to avoid the proceedings in vacuum and in error. Yes, court must observe that actually by the time we made those submissions, our land colleague was not in court, and I think it was half brief. The points of law were as follows. One,
Your Honor, I want to object to how my learned brother is proceeding.
Your Worship, it is housekeeping issue because to avoid, because they are not sure if the complaint.
No, the court has a report.
Most of
And the
them.
court is done that is going to be
Most of them. Most of them.
Let's take me. If you feel you are not covered, hold the objection. Respond.
Most of them.
Your Honor, my learned brother went ahead and quoted section, rather Article 28, 7. Your Honor, for avoidance of doubt, will allow me again quoted verbatim. No person shall be charged with or convicted of a criminal offense which is founded on an act or omission that did not, at the time it took place, constitute a criminal offense. Your Honor, the charge sheet is very clear. Your Honor, the particulars there, read briefly, that this offense, incitement to commit an offense, was committed on the 4th day of September 2025. Your Honor, the penal code is as old as 1957, if I recall very well, Your Honor. Your Honor, the offense with which the accused is charged has been in our law books, and particularly the Penal Code Act. Since then, and is still in the law books. Your Honor, so the argument that the charge was the accused brother was charged retrospectively is really misconceived. Your Honor, the ordinary meaning of the word retrospective is that the law beg your pardon, is that retrospective means looking back. Ordinarily, Your Honor, I give the ordinary meaning of the word. Your Honor, I have established, unless my learned brothers will dispute that the penal code was not in effect as early as that. We pray that this court actually overrules that objection. And that in fact, we pray that the court confirms the offense was committed as the charge sheet indicates after the enactment of the Penal Code Act. Your Honor, I'm not sure what they intended to achieve, but this was, I hope, not a deliberate attempt to mislead this honorable court. Your Honor, when the issue of the council also submitted that that this was a disguised transfer or assignment of the charge sheet. And they say, and they submitted that it was illegal. Your Honor, under Article 120 of the Constitution, of the Republic of Uganda, Your Honor, it provides the functions of the Office of the Director of Public Prosecution. But also particularly Article 120, Sub-Article 3, B. Your Honor, if I may quote verbatim, functions of the Director of Public Prosecutions are the following, and the B particularly to institute criminal proceedings against any person or authority in any court with competent jurisdiction other than the court martial. Your Honor, it was well within the powers of the Director of Public Prosecution and enshrined under the article I cited that this case was registered in this honorable court and the accused was invited to take plea. Your Honor, my learned brothers, counsel for the defense, called it a disguised transfer. Your Honor, I do not know what about it is disguised, as this charge was brought to this honorable court in the light of day. Your Honor, they submitted that the same charges had been dismissed at Nakawa court. Your Honor, I left to wonder what dismissal in one court has to do. Moreover, Your Honor, for all beg your pardon, Your Honor, the same charge, they went on to state that the prosecution was abusing the legal process. Your Honor, and no submission was made to address their skewed assertion. Your Honor, it is the provision of the Constitution that the Director of Public Prosecution is at liberty to refer Your Honor, if I may invite this court to consider sections 85 and 88 of the Magistrates Court Act. Because at this point I am respectfully to my learned brothers, I guess they had not probably addressed their minds to sections 85 and 88 of the Magistrates Court Act. Your Honor, the invitation to dismiss the charge for being effective was not proper for the reasons that are found in these sections. And if you allow me, Your Honor, to quote the sections that I will pray this honorable court considers. Section 85, contents of a charge. Every charge shall contain and shall be sufficient if it contains a statement of the specific offense or offenses in which the accused person is charged, together with such particulars as may be necessary for giving reasonable information as to the nature of the offense charged. Your Honor, if you will be pleased, the charge sheet that was filed in this honorable court, it clearly indicated the statement of offense, that is the incitement to commit an offense, contrary to section 21, subsection 1 of the Penal Code Act, Cap 128. Your Honor, the said charge sheet also had particulars of the offense. And if you allow me, Your Honor, the pertinent Your Honor, in answer or compliance with the Section 85, the reasonable information that were included in the particulars that the accused may not be prejudiced, Your Honor, and that they should know why they were being charged, included the dates on which the offense is said to have been committed, where the offense was committed, against whom the offense was committed, and the persons that were being invited to engage in this heinous charge that the accused is being, or rather alleged to have committed. Your Honor, it is our submission that these were sufficient and reasonable information, and it was in compliance with Section 85 of the Magistrates Court Act, Your Honor, we invite the court also to consider Section 88, which provides for the rules of the Magistrates Court Act, which provides for the rules of framing of charges. Neither one of the about 15 rules were offended, and if there was any, Your Honor, the defense did not point out any of them. You know, the rules from A to R are very clear and self-explanatory. But if I may briefly indulge the court, A provides a count of charge shall commence with a statement of the offense charge called the statement of offense. B, the statement of offense shall describe the offense shortly in ordinary language without necessarily stating all essential elements of the offense. It goes on and on and on. C, if I will briefly also quote C, after the statement of the offense, particulars of the offense shall be set out in ordinary language in which the use of technical terms shall not be necessary. Your Honor, none of these rules of framing charges was offended by the prosecution. It is our firm belief and submission that the accused was very well sufficiently aware of the charges that he faced, and respectfully, we believe that this was intended to waste court's time. Your Honor, the accused also impressed upon court, or rather submitted, and in his own words, for several times, and I quote, "I applied for bail and I was denied. I am innocent and it will come to pass. But what is baffling is that when the matter was dismissed, I was brought to this court." Remember, he meant when it was dismissed in Nakawa, I was brought to this court. "I am being abducted from different courts." Your Honor, he goes on, the state is in a fishing expedition where they throw me at the court of their choice. Your Honor, it is on record that the charges in Nakawa Chief Magistrate Court were dismissed for the charge was being, rather for the reasons that the charge was effective. Your Honor, the accused was on a production warrant produced before this honorable court. Your Honor, and if I may recall, the officers, they have been put on record that the accused deliberately disobeyed their lawful orders, that a production warrant had been issued, and that was why he had been brought before this honorable court. Your Honor, but we find that to be an obiter in this application of the defense or the accused, that the charge was effective. But I thought it was to address the same. The accused deliberately disobeyed orders, and as such, it cannot be said to be an abduction where the court, this honorable court, issued production warrant. Your Honor, no submissions were made on how charging the accused had the prosecution in abuse of the legal process. I've referred this honorable court to section 120, rather article 120 of the Constitution, which gives this honorable court, or rather the Director of Public Prosecution, powers to charge. Your Honor, maybe lastly, the defense or counsel for the accused also cited the case Kasivante Moses versus Katongole Singh and another, in which the court, Justice Chibuka Msoke, have said that the term jurisdiction is not a term of art, but a term of law and a term of very expensive legal import. Your Honor, it appears that their objection rotates around whether this court in fact has jurisdiction, because if they are quoting case law and inviting the court to rely on the same, then let's have it. Your Honor, this court who submit has the jurisdiction to try the offense with which the accused is charged, Your Honor, the charge sheet is explicit that the offense was committed at Makerere Kavule, Wandegeya, within Kawempe Division. Your Honor, if I will also refer this report to the magisterial areas in judicature, Your Honor, that said, Kavule, Wandegeya, falls under this report. Your Honor, my learned brother's counsel went on, and I find the rest really was obiter and of no a waste of time, Your Honor, if I responded to some of their Your Honor, the state. Your Honor, I am really ashamed to reproduce some of these. I will leave it at that. We pray that this honorable court dismisses this objection as no valid reason was advanced to support their objection, dismiss the charges, for which in their language was a disguised transfer and a defective charge that was never supported by any submissions as to point out how defective the charge was. We suffered.
Your Honor, in a quick rejoinder to the reply by counsel for the state. Counsel for the state has alluded to the fact that the law within which the accused person was charged was amalgamated in the penal code way back in 1967. 57 legal fact. And there is no injury caused while refiling charges against the accused. Your Honor, I will begin by defining retrospective. Your Honor, the Black Law Dictionary defines retrospective as legislation that lacks backwards or content as legislation that looks backwards. That is my Lord, that looks backwards or contemplates the past, affecting acts or facts that existed before the act came into effect. It is essential applies new legal consequences to events that occurred prior to the event. Your Honor, the Oxford English Dictionary defines retrospective as thinking backwards in regret. In my objection to the charges, I categorically stated that the accused person was once charged in Akawa Magistrate Court with the offences similar to the charges before you. The same were dismissed. I categorically stated that the charge sheet currently before you affects the accused person retrospectively. In my submission, Your Honor, I did not say that the law within which the accused was charged is retrospective. Because this is the law to be retrospective, it should either be repealed or revised or amended. I did not say that, Your Honor. But what I said, Your Honor, was the effects, the omissions, the commissions of the prosecution, prosecuting the accused persons while taking him backwards. This is what I meant. Yes, Your Honor. To the charges that were dismissed, yet there is a remedy for that, which I alluded to. Your Honor, when the charges were dismissed at Nakawa, allow me to read the last paragraph of his ruling at the Chief Magistrate's Court at Nakawa. The second last paragraph. It reads, therefore the charge sheet remains unclear due to lack of proper particulars, which is a critical consideration while preferring the charges for purposes determining the jurisdiction. Your Honor, I would invite court to look at the provision of section 32 and 39 of the MCA. Your Honor, if you allow me, 32, 35 and 39 of the MCA. And I'll begin with the 32. Accused person to be sent to areas where offense committed. When a person charged, when a person accused of having committed an offense within Uganda has escaped or is removed from the area within which the offense was committed, is found within another area, the magistrate's court within whose jurisdiction the person is found shall cause him or her to be brought before it and shall, unless authorized to proceed in the case, send the person in custody to the court within whose jurisdiction the offense is alleged to have been committed or required the person or give security for his or her surrender to that court, there to answer the charge and to be dealt with according to law. Your Honor, the magistrates at Nakawa, having found that the matter was not within its jurisdiction, decided to dismiss and did not prefer or did not send the charges to Kawempe. The law requires that once court establishes that court has no jurisdiction there, it causes it to be transferred to a court which has jurisdiction. Your Honor, we jump to the areas as section 39 of the MCA. The High Court to decide the cases of doubt. Whenever any doubt arises as the court by which any offense.
My learned brother, in rejoinder, should be restricted to what I have raised. He is raising really new issues, and this is not proper. I invite the court, if anything, to expand his submissions. Your Honor, I have not in my submissions. I have responded only to the issues they raised in their objection. Your Honor, he seems to bring up new issues in his rejoinder. I pray that he is called to order.
Your Honor, Counsel for the State alluded to section 88 and 85 of the MCA, which says that the rules requires confirming the charges. I'm using the same provision of the law. 88. Most obliged by that.
But I think essentially in your response, questioning why they were looking there and the questions that arose. So it's not the order.
Most obliged. Your Honor, I was saying that High Court, section 39 of the MCA, High Court to decide in cases of doubt. Where any doubt arises as the court by which any offense should be tried, any court entertaining that doubt may, in its discretion, be reported the circumstances to the High Court, and the High Court shall decide by which court the offense shall be tried. Your Honor, when the Justice Court realized that it had nothing to do with the matter before it decided to dismiss it. And prosecution never moved the court to take the same to High Court for determination or decide which jurisdiction it should be handled. Instead, Your Honor, it preferred fresh charges. I was about to say that the prosecution offended the principle of double jeopardy, but I will not, Your Honor, for the provisions on most of right, Your Honor. In summary, Your Honor, it's a fact that court judgments are retrospective in nature. And the only remedy for any aggrieved party to challenge a court judgment, Your Honor, is either by going to a superior court for an appeal or seek for review of the same. None of the two was done by prosecution, Your Honor. This is the reason why I prefer the acts of the prosecution charging the accused person retrospectively for the acts that were already concluded or done with. Only a number of cited cases refer to retrospective. And in a case of civil suit number 497 of 2018, civil suit number 497 of 2018, Kanyanya, Joshua and others versus Wantante, Samuel and others. Lady Justice Florence Nakachwa. Cited with authority. The case of Philip Ayera, 1870, LR 6QB1. Saying retrospective laws are not doubt prima facie operational policy and contrary to the general principle that legislation by which the conduct of making is to be regulated ought, when introduced for the first time, to deal with future acts and ought not to change the character of past transactions. She further on her ruling at page 4, cited with authority the case of Wambeo versus Mazarele, miscellaneous application number 128 of 2013, where Justice Henry Kawesa stated that laws that govern legislation and statutory interpretation are to the effect that laws should never have retrospective applications and enforcement. Your Honor, the key word is here is enforcement. By charging the accused person on matters that we have already decided, is a clear retrospective application and enforcement on the accused person. In the conclusion, Your Honor, I retaliate my earlier prayer that the charge and the charge sheet is incredibly defective and it should be dismissed. Your Honor, I'll invite my colleague to substantiate on the issue of the reply.
I stand as I introduced and I will briefly talk about or rejoin as far as the abuse of court process by the prosecution is concerned. That was the second segment that formed the basis of our point of law for you. In the same vein, I also substantiate on why we are saying it is transfer or assignment of a charge sheet from Nakawa to this temple of justice, Your Worship. Your Worship, one, my land brother for the prosecution informed the court that actually the state or the DDP has the mandate to open up criminal charges either deemed fit. Your Worship, that mandate is not absolute. Under the same provision which my land brother read out, that is Article 120. Actually, it dictates and it cautions the DPP not to abuse that mandate. I'll draw your attention, Your Worship, at Article 120, Clause 3B. That says that the functions of the Director of Public Prosecutions are the following. B. To institute criminal proceedings against any person or authority in any court who is competent jurisdiction other than a court function. The catchword, Your Worship, in this provision is the DPP should institute criminal proceedings in courts with competent jurisdiction. Your Worship, it is a considered fact by the prosecution here that the accused person was charged with the same offense with same facts before Nakawa court, where he spent 6 months.
Your Honor, objection. There is nothing considered about the facts. There is nothing considered. We object to that.
Your Worship, the record is clear. You have already know. He said that actually the accused person was, his case was dismissed from Nakawa. Your Worship, that is an English word. You can concede by not necessarily saying I concede. But when you go so bad, but Your Worship, it is not in doubt that the accused person before you was prosecuted over the same offense with the same facts since the month of September 2025 to 12th day of February 2026. Not on its court's volition, but after us as defense lawyers raising numerous points of law. Your Worship, the DPP is employed and growth with a number of lawyers. Why this provision was inserted in the Supreme Law of this land is to avoid abuse of court process. One, Your Worship, will further invite your attention to Clause 5 of the same provision, Article 120. It dictates in exercising his or her powers under this article, the Director of Public Prosecution shall have regard the public interest. And Waiswa, Alex Mufumbiro, is one of the public interests. The interest of the administration of justice and the need to prevent abuse of court process. Your Worship, I don't know which evidence you require from the defense lawyer to agree with us entirely that prosecuting a person in a court with no jurisdiction for over 6 months, it is not an abuse of court process. Therefore, I call upon you, Your Worship, that you be inclined on all of us to agree with us that was a blatant abuse of court process. Your Worship, my land brother said that we never wrote evidence, but all these provisions I'm reading now were read when we are making this application. Your Worship, abuse of court process was defined in the Supreme Court. That is Supreme Court Civil Appeal number 8 of 2004. Attorney General and the Uganda Land Commission were the appellants, were versing James Martha Kamoga and James Kamara. Your Worship, while defining abuse of court process, the bench at Supreme Court had this to say. That abuse of court process involves the use of the process for an improper purpose or a purpose for which the process was not established. They also went ahead to invoke the definition of Bracker's Law Dictionary, 6th edition. That reads that a malicious abuse of legal process occurs. That's why I'm looking at your fingers, Your Worship. Your Worship, where did you stop by? Most of right. From the key citation? Yes. That it is okay, Your Worship, I give with the number of cases. Most of right. I was expecting a ruling. I wanted to give you that. Most of right. Be that as it may, Your Worship, proceed from where it is. Abuse of court process involves the use of the process for an improper purpose or a purpose for which the process was not established for. This is Supreme Court communicating. They went ahead, Your Worship, to also invoke the definition as premised from Bracker's Law Dictionary, 6th edition. That malicious abuse of legal process occurs when the party employs it for some unlawful object, not the purpose for unlawful object, not the purpose which it is intended by the law to effect. In other words, a perversion of it. Your Worship, your judicial attention is called to look at section 34 and 35 of the Magistrate Courts Act. Your Worship, 34 states ordinary place of trial. We are dealing with the same DPP. There's no difference between a state attorney here and state attorney in a house. Subject the provision is relating to transfer conferred by this act.
Kuno kwogatta n'amawulire agafa mu sekita ez'enjawulo. Tugoberere ku YouTube, Facebook, Twitter ne TikTok. Mega Promotions TV. Oyagala okumanya ebifa mu nsi nga bw'etambula, biki ebifa ku serebuwo, ebisanyusa wamu n'ebikuzimba. Oyagala okumanya ebifa mu entertainment industry mu nsi yonna, okutwaliza awamu, okuno kwogatta n'amawulire agafa mu sekita ez'enjawulo. tugoberere ku YouTube, Facebook, Twitter ne TikTok. Mega Promotions TV. Oyagala okumanya ebifa mu nsi nga bw'etambula, biki ebifa ku sereebu wo, ebisanyusa wamu n'ebikuzimba. Oyagala okumanya